Hi everyone, Kim Roberts here. I just saw this morning that the Religious Discrimination Bill went through the lower house, the House of Representatives, this morning, very early in the morning, and I saw a couple of responses online from Australian Christian Lobby and from Lyle Shelton. There are a couple of others who responded to it and expressed real concern in relation to it going through and what might happen to it when it hits the Senate and if it should go through. And I thought, I haven't really looked properly at the Religious Discrimination Bill, so I thought I had a little bit of a look at it, and I want to just give you my take on it. Now, this is not I'm not a student of law or anything like that, and the implications of this bill, I've only just started to look at it, so and I'm not putting this forward as accurate or anything like that, but it's my best shot at it at this moment. I just spent about an hour writing an explanation on Facebook regarding this bill that's going through Parliament, and then the whole lot disappeared, and then a little pop-up from Facebook came up to say that they had a problem that they needed to fix, which I thought was wonderful. Anyway, this is a shorter version, and I'm going to read it off my screen because I didn't want to just ramble on about it. I wanted to be a bit more succinct, so I hope you don't mind that I'm reading this. The Religious Discrimination Bill is an attempt to protect the rights of religious institutions to maintain their free expression of belief and culture, while at the same time protecting others from unlawful discrimination. Of course, the bill decides what is lawful discrimination and what's unlawful discrimination. The very need to have a Religious Discrimination Bill is I guess a response to the Sex Discrimination Act of 1984, which is worded in such a way that it can be interpreted very broadly, potentially eroding the rights of religious institutions to define and express their own beliefs. Now, before I get into this, two things need to be said. Firstly, discrimination is not evil in and of itself. To discriminate simply means to be able to discern the difference between two things. We do it every time we choose the salad over the cake, or the cake over the salad, the blue chair over the beige one, and ask young people to leave a seat on the train for the older people or the disabled. We do it when we choose one school as opposed to another one to send our kids to. Discrimination can be wonderful and appropriate, or it can be unjust and wicked. We don't permit people to pad up with their cricket gear and enter a football match. We don't assign male teachers to supervise the girls' change room at school sporting events. Discrimination can protect, or it can do damage. The failure to discriminate can do the same. The second thing that needs to be said is that legislating in the area of human rights is a difficult process. It is hard to get the right balance between the so-called rights of one group over and against another group. It's easy to cry out in the streets and demand broad rights for this group or that one, but it is really difficult to find out how that all plays out if the rights of two groups clash with each other. Which group's rights have the greatest significance? For some reason, we think that that we can somehow cater for the rights of every single group and cater for them equally. In the family context, that issue is easily sorted. If little Jimmy decides his rights to satisfaction by being allowed to eat Cocoa Pops for breakfast until his teeth fall out, his desires can be dismissed by the voice of a loving and responsible parent. As a child heads into teenage years, the clash of wills often requires careful negotiation, much love, humility on both parties, and listening, and some tough decisions sometimes. In society and in law, the issue of rights becomes a lightning rod for all sorts of clashes, demands, brash and uncaring relating between different groups. It's too easy to draw up battle lines, to lambast one party, to present ideas and rights simply in relation to one group or in relation to another. Add to that the political pressures to placate the powerful lobby groups of the day, the guardians of the spirit of the age, let the reader understand, and the desire for re-election to be all things to most men. Consequently, rights legislation looks all tickety-boo until you try and work out what it means in the detail and where the rubber meets the road. Enter the Sex Discrimination Act of 1984. I've included a transcript of what I'm saying, and I've included a URL for that particular legislation, the Sex Discrimination Act of 1984. Now, that act has been amended along the way in various ways, but it is the same significant act that I've put the URL for. This act was established in order to protect certain groups from unjust discrimination in workplaces and in the educational setting, etc. The sections that are particularly relevant to religious institutions, institutions of education like Christian schools, Muslim schools, are Section 21 and Section 38. I'll include them both here and on the transcript. Section 21, I'm just going to read out what that section says, and it's a section on education. It says, it is unlawful for an educational authority to discriminate against a person on the ground of the person's sex, sexual orientation, gender identity, intersex status, marital or relational status, pregnancy or potential pregnancy, or breastfeeding. Point A. By refusing or failing to accept the person's application for admission as a student, or B, in the terms or conditions on which it is prepared to admit the person as a student. Point 2, it is unlawful for an educational authority to discriminate against a student on the ground of the student's sex, sexual orientation, gender identity, intersex status, marital or relationship status, pregnancy or potential pregnancy, or breastfeeding. Point A, under 2, by denying the student's access or limiting the student's access to any benefit provided by the educational authority. B, by expelling the student, or C, by subjecting the student to any other detriment. 3, nothing in this section applies to or in respect of a refusal or failure to accept a person's application for admission as a student at an educational institution where A, the educational institution is conducted solely for students of a different sex from the sex of the applicant, or B, except in the case of an institution of tertiary education or training at the level at which the applicant is seeking education or training is provided by the educational institution only or mainly for students of a different sex from the sex of the applicant. Point 4, this section binds the Crown in right of estate. Point 3, A and B, really is talking about the person, for instance, the parent who is trying to enlist their boy into a girls' school or their girl into a boys' school. It's basically saying that this doesn't apply, that isn't considered unlawful discrimination. In other words, to be able to tell the difference between a male or a female and to have an institution that's just a boys' school or a girls' school is okay, or if it's a tertiary institution, if it's a course just for boys or men or just for women, that's considered okay. Now, this section 28, it's pretty broad. Sorry, section 21 is pretty broad. It certainly leans in favour of the rights of those who might feel discriminated against by a religious institution on the basis of sex. Note in particular point 2C, which says it is unlawful to discriminate by subjecting the student to any other detriment. What could that word mean, detriment? Now, I've just checked up a sort of a legal definition of it. It's just one legal definition, but it gives you an idea of what it means legally. Any loss or harm to a person or property, relinquishment of a legal right, benefit, or something of value. Detriment is most frequently applied to contract formation since it is an essential element of consideration, which is a prerequisite of a legally enforceable contract. To incur detriment means to cement a promise by either refraining from doing something that one has a legal right to do or by doing something that is not under any legal obligation to do. I guess the idea there is to say, what does harm mean? What does detriment mean? What does harm to a person mean? In the light of the culture today, a harm can be could be interpreted, my feelings have been hurt. I felt offended, I felt stressed, I felt anxious in some way. Now, obviously, the Act doesn't define what it means, and I guess this is one of the problems with creating bills of rights, if you like. It's very difficult to define the specifics of what the right actually covers. But here they've simply said that there's not allowed to be detriment of some kind. Now, consequently, Section 38 has been included in the Act, which tries to present a little bit of balance, to consider the rights of religious schools, etc., to express and live out their beliefs together. I've included the URL for that in the transcript. Section 38 basically puts limits on what can be considered unlawful when it comes to discrimination in a religious school setting. It allows religious schools to choose staff that hold the same beliefs, that's in Section 38(1) and 2, and allows discrimination, in other words, there to be a distinction is allowed to be made if it helps to avoid injury to the religious susceptibilities of adherents of the religion or creed. Note too that the discrimination has to be performed in good will, which is to say that it isn't to be done with a malicious intent, but in order to protect from injury the people who have the beliefs of the community. In other words, Section 38, particularly Section 38C, when it comes to in the educational context and dealing with students and what have you, it's a protection of the rights of a religious institution to actually express itself as a religious institution. Now, how that plays out, the details of that isn't clearly defined. They don't really define the nitty-gritty, if you like. What is meant by detriment? What is meant by goodwill? What is meant by injury to susceptibilities? Each group has susceptibilities and is open to injury of some kind. Again, this is an attempt to curb the broad rights of people who feel like their sexual rights are being impinged in some way or being discriminated against from Section 21. So 31 is an attempt to balance it up. Section 21 is in favour of people of various groups within who might be sexually discriminated against. And can I say, some of those groups that are mentioned, there's much debate about them as even categories, but certainly Section 21 works in favour of not discriminating against those groups. And Section 38 helps to redress the imbalance, if you like, by giving some rights to the religious institution and the religious culture and expression of that school. Well, this is where the last 24 hours in Parliament has got really interesting. Parliament voted for an amendment that would erase Section 38C, and that has gone through. They basically erased it at the level of the House of Representatives. It's now gone up to the Senate for them to have a look at it. This means that the balance that allowed one to discriminate in goodwill in order to avoid injury to people within the faith community is being erased. Any attempt to bring a balance has therefore been removed. And it doesn't stop there, and this is, I guess, the thing we'll see how this plays out. There are hopes among some that further amendments will be made in the Senate that will further erode any balancing of rights on behalf of faith communities. And I'm assuming that refers to 38 Section 1, Section 38(1), sorry, and Section 38(2), which has to do with the right of a religious institution to select staff and contract workers there who also uphold the faith and the beliefs of that particular community. Like I've said, this is a difficult area. Whenever you try and put into legislation the specifics of rights, it's very difficult, and the clashes of the two groups, if you like, come into play. It's one of the reasons why ACL has asked that the whole Religious Discrimination Act actually just be put aside, and that the government actually withdraw it, because it just creates too many possibilities for injustice to occur later. I just wanted to share this stuff just so that you'd have an idea of where this goes. Obviously, as an audience, you may lean toward the rights that protect the risk of discrimination against different groups when it comes to sex discrimination. You may lean in the other direction, preferring to protect the rights of religious communities. All I'm doing is pointing out that the two are there. The moment you put something into legislation, you will you basically have legal power to criminalise and to treat as criminals certain behaviour. Now, usually in a family, this sort of behaviour is worked out. I don't mean criminal behaviour, it's only criminal if it's legislated. But in a family, rights between parents and kids are worked out in the context of relationship. You put it into law, suddenly it has massive clout to actually criminalise certain beliefs, certain activities, certain expressions. Yeah, so I thought I'd just share that with you. I hope you find that helpful.